The secret trust evolved as a response to the Wills Act 1837, which was the precursor of the Succession Act 1965 and its precursor, the Statute of Frauds 1695. These acts impose certain formal requirements for the creation of a valid will. All valid wills must be executed in writing, signed by the testator or some other person in his presence or by his direction, and the signature must be attested by two witnesses at the same time and in the presence of the testator. The function of the secret trust is to keep the identity of the object or beneficiaries under the trust a secret. A will is a public document. A testator may wish to make provision for a lover or non-marital child to ensure they are provided for after his death. However, on death, the will is submitted to the public probate office. If the probate office deems the will to be valid, it will then be admitted to probate. At this point, it can be inspected by any member of the public at the probate registry office. The secret trust attempts to keep the object of the trust from the eyes of the world and the other beneficiaries. The usual method is to leave property to a friend under the will, having extracted a promise from him that he will hold the property for the benefit of the secret beneficiary. The person who, on the face of the will, receives the property is called the secret trustee. In fully secret trusts, he is termed the ostensible beneficiary. The person who is to receive the benefit under the trust is called the true beneficiary. Problems arise when the secret trustee, that is, the person receiving the gift on the face of the will, seeks to take the property given to him under the trust beneficially by arguing non-compliance with the terms of the Succession Act 1965. A court, when faced with this situation, may abide by the Act and allow the secret trustee to take the property beneficially. Alternatively, it may force the secret trustee to hold the property on resulting trust for the testator's estate. Finally, the court may decide to give full effect to the testator's wishes and enforce the secret trust, notwithstanding the terms of the Succession Act. This final alternative is adopted when courts recognise the existence of a secret trust. There are two types of secret trust, the fully secret trust and the half-secret trust. In a fully secret trust, the donee or legatee appears from the face of the will to be taking the property beneficially under the will. There is no indication that a trust obligation has been imposed on him. For example, imagine a bequest of €100,000 to John. In a half-secret trust, it is clear from the face of the will that the donee has received the property on trust. However, the object of the trust is not revealed on the face of the will. In a half-secret trust, one might have a bequest of €100,000 to John to hold for such persons as I have already communicated to him. Although there are no cases directly on this point, the doctrine of the secret trust is thought to be not limited to testate succession. It is similarly relevant to cases of intestacy, where the deceased has refrained from making a will on the strength of a promise by a kinsman that he would apply it for the benefit of a third party. This kinsman would receive the property under the intestate succession rules. In this situation, a secret trust may bind such person, and equity may force them to hold the property in question as trustee for the benefit of the intended beneficiary. In McCormick and Grogan, Lord Westbury said, "The courts of equity have from an early period decided that an Act of Parliament shall not be used as an instrument for fraud, and if in the machinery of the attempted fraud an Act of Parliament intervenes, the courts of equity, it is true, do not set aside the Act, but equity fastens on the individual who gets a title under the Act and imposes on him personal obligations to prevent the application of the Act as an instrument for accomplishing a fraud. In this way, the Court of Equity has dealt with the Statute of Frauds, and in this manner also it deals with the Wills Act." In McCormick and Grogan, the donor on his deathbed sent for Grogan and told him of a letter containing his will. The testator did not expressly ask Grogan to comply with the letter in question. The letter named certain named beneficiaries, but also provided, quote, "I do not wish you to act strictly to the foregoing sections, but leave it entirely in your good judgment to do with as you think I would if living, and if the parties are deserving," unquote. The House of Lords held that the testator had not intended to impose a trust obligation on Grogan. McCormick was named beneficiary in the letter but received nothing. He sued Grogan, but his action failed since there was no legally binding obligation on Grogan to hold any property for McCormick's benefit. McCormick was not a secret beneficiary. Fully secret trusts. Lord Westbury noted 3 requirements for the creation of a valid secret trust. 1. There must be an intention to create a trust. 2. There must be communication of the donor's intention to create a trust to the donee. during the lifetime of the donor. And 3, there must be acceptance by the legatee/secret trustee of the trust obligation. In Walgrave and Tebbs, the testator left £12,000 and certain lands to 2 persons apparently beneficially as joint tenants. Shortly before his death, he asked the executor to write to the donees telling them of the objects to which the trust fund was to be applied. The executor wrote the letter but never sent it. It was held that the donees were entitled to the property beneficially on the testator's death because the secret trust obligation was not communicated to them. If some of the terms are not communicated to the donee or are communicated after the death of the testator, then the trust will fail. For example, in Re Boys, 1884, the testator made a will leaving his estate to his solicitor, who was the executor of his estate. The solicitor had drawn up the will and gave oral evidence that the testator had intended him to hold the property as trustee for objects to be subsequently indicated to him. The testator never indicated to him these objects during his lifetime, but after his death, a letter from the testator, addressed to his solicitor but never handed to him, was found in the testator's bureau. It indicated the objects which were to benefit under the secret trust. The solicitor accepted that he held the property as a secret trustee and wished to carry out its terms. Mr. Justice Kay held that in order for there to be a valid secret trust, the terms must be communicated to the trustee in the testator's lifetime, and the trustee must accept the trust. It was held that there was a resulting trust in this case in favour of the testator's next of kin. The fully secret trust could not be enforced. However, the learned trial judge did go on to state that it may possibly be that the legatee would be bound if the trust was put in writing and placed in his hands in a sealed envelope, and he had engaged that he would hold the property given to him by the will upon the trust so declared, although he did not know the actual terms of the trust." Unquote. And so, in Re Keen's estate, £10,000 was left to A and B to be held on trust and to be disposed of by them among such persons or charities as may be notified by me to them or either of them during my lifetime. Unquote. Before making his will, the testator handed a sealed envelope to B, indicating that it was not to be opened until after his death. When the testator died, the envelope was opened and a woman's name was found within. On the facts, this was found to be an invalid attempt to create a half-secret trust. Purporting as it did to reserve to the testator the power to make future testamentary dispositions, this part of the will was inconsistent with Section 9 of the Wills Act. However, significantly, Lord Wright considered that regardless of this fact, the trust failed for inconsistency. The phrasing of the will indicated an intent to define the remit of the trust at a future date, yet ostensibly the detail of this trust had been communicated to and accepted by the trustees already, when the sealed envelope was handed over. Acceptance of the secret trust obligation by the donee. If the donee does not accept the trust obligation, he will hold the property on resulting trust for the testator's estate. There can be no question of the donees taking beneficially once they have been aware of the existence of the trust. Acceptance of the trust obligation can be implied. So, in Ottaway and Norman, the testator left his bungalow and its contents to his housekeeper. He mentioned to one of his sons in the housekeeper's presence that he intended the house to be hers for life, and after her death it was to pass to his sons. The housekeeper later received the property under her late employer's will. She, in turn, made a will leaving the house to the sons. However, she later changed her will and purported to leave the property to a friend. It was held that the house was the subject of a secret trust. There was strong evidence that the housekeeper understood and implicitly accepted the trust obligation at all times. If the testator wishes to make any addition to the trust property, again he must comply with the 3 requirements mentioned earlier. In Re Colin Cooper, the testator made a will leaving £5,000 on secret trust to 2 persons jointly. Communication was made to both at the time the will was made. The legacy was then increased by a further £5,000, and a term was included in the will which provided, quote, "they, knowing my wishes regarding that sum, etc., etc., unquote." However, no mention of the increase was ever made to the donees during the testator's lifetime. The Court of Appeal held that there was a valid secret trust of the first £5,000, but not of the second. The court reiterated that all the terms of the trust must be communicated to and accepted by the donees. It is submitted, however, that a decrease in the trust fund does not require further communication to or acceptance by the donees. Particular problems have arisen where there are multiple trustees, but some have not been informed of the trust's existence. A somewhat unconvincing distinction is said to exist between trustees who hold as joint tenants and those who hold the trust property as tenants in common. This is known as the rule in re stead. Where property is transferred to trustees as tenants in common, the secret trust will only bind those donees who have accepted the trust obligation. The others will take beneficially if they do not have notice of the trust. However, where property is transferred to trustees as joint tenants, the trust obligation will only bind the accepting trustee if the will was made before his acceptance. The other donee will be permitted to take beneficially. However, the trust obligation will bind both of them if the settlor made his will after the accepting trustee's acceptance. Half-secret trusts. A half-secret trust arises where there has been a testamentary disposition of property, yet it is clear from the terms of the will that the donee is to take as a trustee and not beneficially. Due to their very nature, the scope for breaches of trust is considerably reduced in half-secret trusts. In Blackwell and Blackwell, a testator left a sum of money to certain persons who were to hold it for the purposes, quote, indicated by me to them, unquote. One of the legatees was informed in detail. The others were informed in outline before the execution of the will. The legatee who was informed in detail wrote out a memorandum of instructions on the same day. The objects of the secret trusts were to be his mistress and their son. Following his death, his wife sought to have the trust declared invalid. It was held that a valid half-secret trust had been created. However, Viscount Sumner noted, obiter, that the requirement for communication of the trust obligation in half-secret trusts is stricter than for fully secret trusts. This distinction continues to exist under English but not Irish law. There is much academic comment declaring the English distinction to be illogical. The only possible justification for it is that the whole raison d'etre for recognising a secret trust is to prevent fraud. The possibility of fraud is drastically curtailed when the trust is half-secret. Therefore, the historical justification for non-compliance with statutory formalities is removed. Lord Justice Walker emphasised that the tenant in common who was not told of the secret trust could only take free from it if the gift to him could be treated as an independent one, and that he would have got it regardless of the undertakings given by the other tenant in common. In the Irish case of Reardon and Bannon, 1876, however, Lord Chatterton adopted a different test to that utilised in Blackwell and Blackwell. While acknowledging that, quote, the same kind of fraud cannot operate, unquote, in relation to half-secret trusts, nevertheless a refusal to enforce such trust would be a fraud on the intentions of the settlor. To be valid in this jurisdiction, a half-secret trust, like a fully secret trust, must be communicated to and accepted by the legatee prior to the testator's death. In Reardon and Bannon, the testator's will directed that a legacy be disposed by the legatee, quote, in a manner of which he alone should be cognizant, and as contained in a memorandum which I shall leave with him, unquote. Prior to executing his will, the testator had verbally informed the legatee that he intended to leave the legacy for a named person whom he did not wish to identify in his will, and it was accepted that the legatee had accepted this obligation. Lord Chatterton held that a valid secret trust had been created. Further confirmation that communication and acceptance of a half-secret trust may validly occur after execution of a testator's will, provided this is done during his lifetime, can be found in the judgment of Mr Justice Overend in Re Brown, a 1944 decision. In Prendeville and Prendeville from 1990, Mr Justice Barron in the High Court reasserted the Reardon authority, holding a half-secret trust valid where there had been communication by the testator and acceptance by his wife of its terms during his lifetime. He refused to follow the earlier English decisions in Blackwell and Re Keane.